Civil lawsuits are legal proceedings initiated by an individual or entity against another, seeking compensation or resolution of a legal dispute. In a civil lawsuit, several parties may be involved, including the plaintiff, defendant, attorneys, judge, and jury. The legal procedures in a civil lawsuit typically follow a series of steps, including pleadings, discovery, pre-trial, trial, and post-trial. The parties involved in a civil case include: plaintiff, the party initiating the lawsuit, claiming to have suffered injury or loss due to the wrongful conduct of the defendant. Defendant, the party being sued, who is responsible for the alleged injury or loss. Attorneys, lawyers who represent the parties and advocate for their respective interests. Judge, a public official who presides over the case and resolves disputes by issuing judgments. Jury, a group of individuals selected to decide factual issues in the case. The following are the main steps involved in a civil lawsuit in a district court. Pleadings, the initial papers filed by each party that explain their side of the dispute. The plaintiff files a complaint with the court, and the defendant has a specific time to file an answer to the complaint. Discovery, the process of gathering relevant information from each other or third parties through written questions, requests for copies of documents, requests for admission, and conducting depositions. Pre-trial, a conference held after discovery is completed to prepare a trial plan and discuss the contents of the proposed pre-trial order. Trial, the presentation of evidence in support of claims or defenses to a jury and/or judge. Post-trial, the court enters a judgment, and the losing party may appeal the decision. Pleadings. The pleadings are initial papers filed by each party that explain their side of the dispute. The plaintiff initiates the litigation by filing a complaint with the court, and the defendant has a specific time to file an answer to the complaint. The defendant may also file counterclaims against the plaintiff. Discovery. Discovery is the process of gathering relevant information from each other or third parties. The clients and their attorneys research the law, review and organize documents, and interview witnesses to evaluate the merits of claims and defenses. The parties collect this information formally through written questions known as interrogatories, requests for copies of documents, and requests for admission. Conducting depositions is another important way to acquire information. Expert witnesses. Sometimes, a claim or defense requires support from expert witnesses to explain technical information or validate an argument. The attorneys might need the testimony of one or more experts to describe the connection between the defendant's conduct and the loss experienced by the plaintiff or the existence and amount of the plaintiff's damages. Motions. Before trial, the parties may use motions to ask the court to rule or act. Motions usually refer to law or facts in the case, but sometimes they seek clarification or resolution of procedural disputes between the parties. Some motions decide issues without trial. Pre-trial. After discovery is completed, courts typically hold a pre-trial conference to prepare a trial plan. The conference is held as close to the start of trial as is reasonable, and at least one attorney who will conduct the trial for each party must attend. Before the conference, the parties meet and consult to pre-mark and exchange all trial exhibits. Trial. At trial, the parties present evidence in support of their claims or defenses to a jury and/or judge. A trial is made up of several components, including jury selection, opening statements, plaintiff's case presentation, defendant's case presentation, and closing arguments. After the post-trial phase, the court will enter a final judgment in the case. If the plaintiff wins, the judgment will typically award monetary damages or equitable relief, such as an injunction. If the defendant wins, the judgment will dismiss the case or award no relief to the plaintiff. If one of the parties is dissatisfied with the outcome of the trial, they may choose to file an appeal to a higher court. The appellate court will review the record of the trial court proceedings and determine whether any legal errors were made. If the appellate court finds that errors were made, it may order a new trial or modify the judgment. If there is no appeal, or if the appeal is unsuccessful, the parties will need to comply with the judgment. This may involve payment of damages, performance of an obligation, or other actions ordered by the court. In some cases, the parties may need to negotiate a settlement or payment plan to comply with the judgment. Once the judgment has been satisfied, the case will be officially closed.